Okay. Okay, so everybody knows we are now recording this webinar session. If you do not consent to participate in the recording, then ask you to leave now so that we can have this recorded for people. So thank you everybody for joining us and welcome again. Just a little bit of background and we'll get to the topic of the week. So first, so Dr. Brian Cutler and Dr. Jeff Kramer are joining us today to begin a discussion about false confessions. And this was kind of started because I've gotten a number of calls from folks who are either having trouble convincing your elected that because somebody confessed they could still be wrongly convicted, or just having trouble analyzing potential false confessions on your own. So I thought I'd reach out to Dr. Cutler because he is one of the nation's leading, well, one of the world's leading experts on this topic, having published and edited many different peer-reviewed journals on the topic. But so in trying to put together the presentation, we kind of figured out that there was a lot more material that we wanted to cover than we really could fairly do in 1 hour. So we're going to actually extend this over 2 weeks. So this is kind of part one, if you will. Part two will be next month, which I believe is June 10th. We'll be completing up the topic. So, but that doesn't mean that we don't want questions now. As always, of course, we do. Feel free to unmute yourself or put it into the chat if you prefer. I'll be monitoring the chat for any questions as we go along. And hopefully we'll be able to have a lot of folks participating in this. Just a couple announcements. One, the Zoom link will change for the webinars going out. So I will try to modify the calendar invite that's already out there. So hopefully it won't clutter up your inboxes too much. But we had to change our Zoom accounts at the Coercion Center. So that will all be changing out, but I will get that done this week, hopefully without too much difficulty for folks. Also wanted to just remind folks that there are 2 deadlines coming up for BJA grants. The Coverdell grant is due June 19th and the Bloodsworth grant is due June 15th. If you have any questions about those grants or need some help applying, just feel free to reach out to me and let me know, and I'll get you connected to people who can answer any questions that you might have. And the last part is that we at the Coercion Center want to start trying to gather documentation from the various CIUs around the country, the templates, the letters that you're using, the forms for folks to fill out, waiver agreements, cooperation agreements with Defense Counsel, written policies and procedures. One of our tasks under the technical training assistance part of the BJA grant is to try to collect all those so that we have a central repository so that when prosecutors are looking to set up a new CIU, we have good information that they can go to. And in the process of that, if you'd like some feedback or some help in trying to improve your policies, procedures, or templates, that's what we're here for too. We'd be more than happy to work with you to redesign if you want to make sure to try to see if we can better yield on information, or even just to have another set of eyes on it. We're happy to do that. So I'll be reaching out in the next couple weeks asking for the prosecutors to provide us with as much documentation as you feel comfortable. Of course, if there are concerns about work product or issues regarding open records laws, we'll work with you around that too. But it just, BJA is just looking to have these centralized so that we can start having a collective for folks who are interested in getting this work done and getting it done right. So thank you in advance for helping out with that. So I am going to now just quickly introduce Dr. Brian Cutler. Dr. Cutler is a professor of forensic psychology at the University of Ontario Institute of Technology. He's been conducting research on eyewitness memory, interrogations, police psychology from a social and cognitive psychological perspective since 1983. His publications include being editor or author of the APA Handbook for Forensic Psychology, the Encyclopedia of Psychology and Law, Reform of Eyewitness Identification Procedures, Conviction of the Innocent, Lessons from Psychological Research, and lots of other publications. Dr. Cutler is also has served as an expert witness in false confessions and I believe also eyewitness misidentifications in court, work both with prosecutors and defense counsel. And I'm just really so thrilled that he is able to join us for this. So thank you very much, Dr. Cutler. I'm going to quiet myself out. Again, as we go along, if anybody has questions, Please feel free to unmute yourself to ask or put it up in the chat and we'll address it as we go. Dr. Cutler.
Thank you. Thank you for the lovely introduction, and really thank you for the opportunity to address this, this unique group. I really appreciate it. So as Marissa explained, my background is largely academic, although I do a fair amount of consulting and expert testimony in cases involving interrogation, coerced confessions, false confessions, and actually, I got my start in the area of psychology of eyewitness identification, so I'm very well versed in that topic as well. My main job is professor at Ontario Tech University. Although I live in the Toronto area and teach in Ontario, I am a U.S. citizen. I was raised in Connecticut. My previous academic jobs were at Florida International University in Miami and the University of North Carolina at Charlotte before working my way in the opposite direction of everybody else up the coast to Canada. In 2017, I formed my company, Coral Coast Group, which has helped me facilitate my consulting and expert witness work and student training. And I really want to emphasize that if you have questions along the way, please ask. I've been teaching for many years. I've taught a lot of continuing legal education, and I truly enjoy the give and take of questions and answer and discussions. I also wanted to mention, as I put the outline up here for today's talk, this is really the outline for what I intend to cover today and in the next session. So I developed it as all one session. We'll see how far into the outline we get today. I would rather not rush through it as we have time and take time for your questions. So we're going to start out with just a little bit of background on false confessions and wrongful convictions. I'm sorry if this is stuff you already know, but we're going to spend a little time on that. We're going to spend more time on the other three topics: understanding false confessions, assessing coercion and interrogation, and evaluating confession reliability. So a little bit about wrongful conviction. This is not a new phenomenon. Scholars have been studying wrongful conviction for many years. If you look at the book cover, the second to the left on your screen at the bottom, Convicting the Innocent. This was a book authored by Edwin Borchardt, who was I believe a Yale law professor. And the book was published in 1932. In that book, Borchardt detailed 65 cases of known wrongful conviction and articulated the factors that contributed to the wrongful conviction in those cases. Basically, every decade since then, there's been another scholarly book on wrongful conviction detailing mort cases, and it really wasn't until the work of the Innocence Project began in the 1990s and the development of DNA evidence that a lot of public attention has been drawn to the phenomenon, but it's been in the academic conscience for quite some time. I'm sure you're familiar with the National Registry of Exonerations. I find this section of their webpage particularly handy. It's the dynamic graphs section, and I pulled a graph from this section basically to illustrate what we're finding about the role of false confessions and wrongful convictions. So on the right-hand panel where you see contributing factors, I clicked on present for false confession and left the other topics, mistaken identification, bad forensic evidence, and so on, open. So they could be present or they could be absent. So this data set was, I pulled this graph, I guess maybe the end of last week. On that day, they had 2,612 exonerations. So we find that 319 of those exonerations had false admissions or false confessions. Most of those were murder cases. And you could see along the bottom line that the number of exonerations has been increasing in recent years. And the report of the National Registry of Exonerations in 2019, summarizing the 2019 exonerations, really highlighted actually the role of conviction integrity units, which were involved in I think probably about 2/3 of the 2019 exonerations. So the number of CIUs has been increasing over the years, and they're playing an increasingly prominent role in the exonerations that are collected by the National Registry of Exonerations. But the main point that I wanted to make on this is that false confession is one of the leading contributing factors to wrongful convictions. False confessions not only contribute themselves to wrongful convictions, but they also have the potential to contaminate other forms of evidence, such as alibi, fingerprint matching, handwriting matching, polygraph chart analysis, and eyewitness identification. There's been empirical research on the extent to which knowing that somebody falsely confessed can alter these other forms of evidence. I wanted to take a minute and explain how it is we know what we know about interrogations and false confessions. What are our sources of knowledge on this topic? We rely on a variety of sources. A lot of what we rely on is basic psychology and basic social science. The sub areas of psychology that we typically teach in our introduction to psychology courses, in our other psychology courses in the major: clinical psychology, social psychology, developmental, cognitive psychology, all contribute to our understanding of what happens in an interrogation process and how it is that somebody comes to falsely confess. Aside from the very much more general research or literature on psychology, there's a substantial and growing body of literature specifically on interrogation and false confessions. And that literature includes case studies. So if you go to the websites of the Innocence Project or the National Registry of Exonerations, you can read about hundreds of individual case studies. And then there are also lengthy books written about individual cases, picking cotton, for example. So case studies contribute. Archival analyses, that is the study of known cases of wrongful convictions based on their records. That's the approach that you would see in Borchards's book, Convicting the Innocents, or in the book published by Barry Scheck and colleagues. They basically reviewed the archives, the records of wrongful conviction cases to understand the processes that led to those wrongful convictions. Beginning in, I would say, the 1980s, social psychologists started conducting psychological experiments in our laboratories on false confessions and the risk factors for false confessions. So in our experiments, you've probably heard of them. You may have heard of the Saul Kassen's famous alt key study. These are our laboratory experiments, typically involving university students who are put into situations where they're accused, falsely accused of some form of misconduct. And then they are put through a simulated interrogation of some sort. In the laboratory experiments, we try to carefully control the environment. We systematically manipulate factors, and we try to measure whether an individual confesses truly or falsely. And although it is certainly the case that in the laboratory research, the environment is relatively contrived, right? We're not examining confessions of real crimes, and we don't profess that the conditions of the laboratory mirror what goes on in the investigation of a murder or another serious crime. But the experiments are important to us because they allow us to do things that you can't do in other kinds of research. They allow us to systematically manipulate factors like the presence or absence of false evidence, or the presence or absence of certain types of interrogation techniques, and examine their effect on true and false confessions. That's an important point. In the experiment, we know whether the confessions are true or false. We don't know that in other kinds of research on interrogations and confessions. We often don't know that for certain. We also use survey research. Survey research is conducted with individuals, defendants who claim to have falsely confessed. They're conducted with police officers to better understand the tactics that they use in interrogations. They just tell us what they do in their interrogations. And we use it to understand the beliefs that police officers and lay people have about the use of interrogation tactics and the risks of false confession, or even whether false confessions are likely to happen. Some research is done as observational studies. This has involved observations in some cases of actual interrogations in real time, more often studies of videotapes of actual interrogations. They tell us a good deal about what happened in these interrogations. But again, with every method, there's strengths and limitations. The strength with observational studies is we get to see what happened in a realistic case. The limitation there is that we can't control factors, and we often usually do not know whether the confessions were true or false.
So Dr. Cutler, if I can interject with just a question
Sure.
here. So what some of the pushback that researchers get on the experiments involving students, for example, is that they're not under the same pressures as somebody who's being investigated for their involvement in a crime. Do you find a balance out between, say, the observational studies and the experimentations to be able to answer that pushback, or is that just something that you have to kind of accept as part of the limitations of the experiment?
Sure. Well, it is something we accept as limitations of the experiments, and the empirical reports. We typically say that we haven't represented what happens in actual crimes. Although we actually do put our students through some stressful situations. Clearly, not what goes on in a robbery case or a murder case. But they take it pretty seriously, and they do get kind of stressed out about it. But ultimately, what we want to see is, do the results of the research from the laboratory experiments sort of map on to the results of the observational studies or the archival studies? And we find that it does. So the lab studies give us increased control and scientific rigor. But they don't give us realistic conditions. The observational studies give us realistic conditions without the ability to control, and in many cases, the ground truth on whether the confession was true or false. But we tend to find that the research findings are consistent across these different research methods, which gives us more confidence in them.
And I think it's important to realize for folks that, and I assume this is correct, it's not like they're being told they're participating in a study on false confessions. They're brought in on another pretense, and then the manipulations occur, and then the observations are made.
That's exactly right. They're not told until they're debriefed at the end of the experiment that the experiment was actually about false confessions and the risk factors for falsely confessing. Other questions? Okay, I'll finish up with this slide. We also rely, when possible, on meta-analyses. For those of you who don't know, a meta-analysis is a technique for systematically reviewing a series or sometimes a large quantity of studies that examine the same variables, like that examine interrogation and false confession or confessions in general. What the meta-analysis allows us to do is quantify the results across experiments and combine the results in really a statistically very powerful way to arrive at some general conclusions about the effect of some factor on some other factors. So for example, the effect of accusatory techniques on confessions, or on true confessions, or on false confessions. So because meta-analyses are combining the results of multiple studies, they tend to be powerful, and they tend to be relied upon. They're often published in our best journals, and we like to cite the results of meta-analyses over the results of individual experiments when possible. Another source of information we rely on in our work is the interrogation training literature. Since physical methods of interrogations were basically outlawed in the 1930s, psychologists, or rather investigators, have been developing interrogation techniques probably since the 1950s based on psychological methods, and have learned a great deal about what works, what gets people to confess, what doesn't get people to confess. I've taken the training offered by the Reed Institute. I'm very familiar with their materials. I also study other materials, such as that produced by Wicklander, Zulowski, and others. There are quite a number of interrogation training books and workshops out there. Many states offer their own versions of interrogation training through police departments. Obviously, I don't know them all. But they're all, you know, from what I can see, there's a lot of similarities among them. And this literature has really been quite informative in our work also. I put on this slide an example of the relevant psychological principles involved in an interrogation and confession, just really to get across. I promise I won't talk about each and every one of these, but I wanted to get across the many ways in which psychology plays a role in the process of interrogation and confession. We have in this slide a mixture of topics that are from traditional clinical psychology, such as anxiety, other personal risk factors. We have cognitive psychology in terms of memory, cognition, cognitive loads. Social psychology involves the study of social influence. Developmental psychology is particularly relevant when interrogating youths or people in their 17, 18, 19, even early 20s are still considered developmentally immature relative to adults. And we're going to get into some of these topics as we go. So I wanted to talk for a couple of minutes about what we call the pathway from false confession to wrongful conviction. How does it happen, and why aren't false confessions sometimes caught earlier in the process? How is it that they can go all the way to wrongful conviction? Well, sometimes they are caught earlier in the process, but Leo and Drizzen in a fantastic 2010 article articulated how it is that a false confession can work its way, can happen and work its way through the system. It begins with what we call classification errors, where an innocent person is mistakenly classified as a suspect or a guilty suspect or a suspect with strong suspicion. Well, how does this happen? Sometimes it's on the basis of evidence. Sometimes it's on the basis of suspicious behavior by the individual. Police have expectations about how innocent people, how guilty people behave when they're being investigated. And when suspects violate those expectations for any reason, it could be something about the individual or the circumstance the suspect is in, that arouses suspicion in the investigator. So when people don't behave in the way that one would expect. So for example, in an investigation of the death of a baby, and say a boyfriend or a husband not showing an appropriate or the expected amount of emotion when being questioned could be a trigger for investigators, and it makes the person suspicious without knowing that this individual might generally have blunted emotion and psychological disorder or psychological makeup that leads to blunted emotion. Police are taught to try to detect when a suspect at an early stage in investigation is being deceptive. We are, as humans, notoriously poor at detecting deception. There has been research for probably 30 or 40 years in social psychology on people's ability to detect deception and meta-analyses of this research. And it shows that we are barely better than chance at telling whether somebody is lying. And police are actually not better at it than lay people. They tend to be more confident in their judgments, but they tend not to be more accurate in telling when somebody's lying. There's really, in the training that police often get about detecting deception, they're trained to rely on cues that actually don't predict deception. And even when we rely on our own instincts, we're often relying on invalid cues to deception. So one way or another, an innocent person gets misclassified as a guilty person. And when this happens, that innocent person may get subjected to an interrogation that has some level of coerciveness in it, some level of pressure. I'm going to get into in a bit what we mean by coerciveness, but think of it as a high pressure interrogation. Interrogators under the Reed technique and other techniques that are fashioned to be similar to Reed actually start with the presumption of guilt when the interrogation phase starts. There are earlier phases of the investigation that involve behavioral analysis interviews where a suspect, where the police try to determine whether somebody is a suspect. But when the interrogation formally begins, it's a guilt presumptive process. And that's conveyed through the tactics that are used by the investigator. So the investigator is trying to get the suspect to confess and then to produce information as part of the confession that can be evaluated by the investigators. So it shouldn't come as a surprise that if you start with a guilt presumptive interrogation strategy, and you put an innocent person in this situation, some portion of them will falsely confess. We know from decades of work by investigators who do interrogations that their interrogators are successful at getting people to confess. And most of the time, these are likely true confessions. But when you put innocent people in that situation and apply the same pressures that you do to guilty people, and we're going to go through what some of those pressures are, when you put innocent people in that situation, some portion of them will end up falsely confessing. So we call that the coercion error. An innocent suspect is misclassified as a guilty suspect early on in the investigation or at some point in the investigation, and is then subjected to an interrogation that is guilt presumptive, and pressure is put on the suspect, and the suspect is persuaded to falsely confess to the crime. Any questions to this point before I get into contamination errors?
Yep, go right ahead.
Okay. You need to go now.
Question? Okay.
Not seeing any in the chat. I think we're good to go.
Okay, we'll proceed. So an innocent suspect has been misclassified as a guilty suspect, has been subjected to an interrogation, and that leads to a false confession. The contamination error refers to how the confession is actually produced. That is the narrative that the suspect comes to hold about his or her involvement in the crime. Ideally, the suspect, in the case of an interrogation of a guilty suspect, the guilty suspect is persuaded to confess and offers up a narrative of what happened, the who, what, when, where, how of the crime, produces facts that only the guilty person would know, guilty knowledge. And then the investigators can go out and investigate those facts and corroborate them with the either evidence that's already in hand or evidence to be obtained. That's the ideal scenario with a guilty suspect. What happens with an innocent suspect is that the innocent person doesn't have the guilty knowledge, so cannot on his or her own produce that detailed narrative. But during the course of interrogation, because of the tactics that are used by the interrogator can convey details that the interrogators know from their own investigation and contaminate the confession itself, suggest details, basically educate the suspect on what happened in the crime. And the interrogator might do this without realizing it, inadvertently communicating information that the suspect can pick up and learn and incorporate into a narrative that the suspect can basically repeat back. Interrogators sometimes ask suspects to imagine information. They sometimes ask suspects to do things like, well, if they're remorseful, if they would apologize, what would you say to the victim's parents? What would you like to say to this person? How do you feel about it? And by asking questions like this, suspects end up even when offering false confessions, issue apologies or expressions of remorse. So they can pick up crime facts from the investigators, sometimes make these other kinds of statements like expressions of remorse. And through that process, the confession can become detailed and compelling and look like something that only a guilty person would give. So that's an overview of the process. Classification errors, coercion errors, and contamination errors that explains how an innocent person can become a suspect, be coerced or persuaded into falsely confessing, and how the confession itself can be contaminated and made to appear compelling when it's not really the suspect's confession. I'm going to spend most of the rest of the sessions on coercion errors and contamination errors. Before I get into, I'll just stop again and see if there's any questions, anything I should clarify, or any questions at all.
Here, I'm actually kind of curious if folks don't mind, if you know how to do a show of hands under the participant bar, there's a reaction, but how many have had a case that you're reviewing now or have worked on that involves an alleged false confession? Looks like several up, okay. So it's something that, and that's from a geographic disbursement, Dr. Cutler, from all around the country. Thanks.
Okay, fantastic. Experienced group. So coercion's an interesting concept. States have their own definitions of coercion. In psychology, coercion has been described as something that one does to another person, that it's largely the experience of I'm coercing somebody else. Sometimes it's described as the psychological experience of being coerced. And then sometimes it's described as the combination of that too, that as well. My doctoral student, Jeff Kaplan, who's in the session, had done a fair amount of research on various definitions of coercion, and for a chapter that we published last year, settled on a definition that tends to work for us in our research. So I wanted to share that with you. Coercion in police interrogation consists of the use of persuasive techniques that limit the suspect's autonomy by manipulating the perceived costs and benefits of possible courses of action, and or depleting the suspect's motivation or ability to resist acceding to the investigator's demands. So let me unpack that a bit. There's really two parts to it. One is the use of techniques that limit the suspect's autonomy by manipulating the perceived costs and benefit of possible courses of action. So this is part of this arises out of interrogation, where particularly guilt presumptive interrogation, where the suspect is led to believe very early on in the interrogation that, look, we're not here to figure out whether or not you committed this crime. We're here to figure out why you did it, or who else was involved, or how you did it. So, and that's a very typical way to start an interrogation, and that idea runs throughout the interrogation. But what it does basically is it takes the option of maintaining one's innocence off the table. It's a form of choice architecture, if you've come across that phrase. We're limiting your options as to what you can do. You can confess to being a sociopath who cares little for what happens to other people, or you can say that this, that this happened in the heat of the moment, that this was an accident. So you do have some options there, but your option to maintain your innocence is not viable. It's not going to fly. Of course, you can continue to maintain your innocence, and many suspects do, but that's the idea of psychologically limiting the suspect's options.
But Dr. Cutler, there are a couple folks who had hands up. I just wanted to see if those are questions or leftover.
Yes.
Megan, you had your hand up. Was that for a question or just still up from a prior question?
I didn't remember to lower it after your
No worries. And Muir1, you also have a hand up. Just wanted to make sure there wasn't a question there.
It's Carolyn Murray. Hi, Murray.
Oh, hey, Carolyn.
I was so excited to raise my hand, but it took me a long time about the false confession.
Okay, fair enough. Thanks. Okay.
First time I ever did it. Okay.
Thanks, Dr. Cutler.
Okay, thank you. Well, the other part of the definition is depleting the suspect's motivation or ability to resist acceding to the investigator's demands. Here we're talking about a psychological concept called self-regulation, self-control. Self-regulation refers to the ability to regulate your own thoughts, behaviors, emotions to serve your own needs. When we are rested, fed, and basically with energy, we have a high ability to self-regulate. But things like fatigue, hunger, pain, and even the act of arguing depletes your ability to self-regulation. For those of you who, if you're anything like me and you're on a diet forever, the morning is fine. You do fine. You wake up with energy and you're eating well. By 7 o'clock, 8 o'clock at night, self-regulation is shot. Your ability to resist a temptation is much, much lower. And over the course of an interrogation, either out of just the length of the interrogation or the intensity of the interrogation, self-regulation abilities become depleted, and we become more susceptible to social influence. So coercion can happen out of at least one of these two methods, and sometimes both are present. So this is our operational definition of coercion in our research. So I want to launch into the subject of risk factors for false confession. And we generally divide it between personal risk factors, what kinds of people are more susceptible to false confession, and situational risk factors. And that's usually the interrogation. What happens to people that renders them more likely to falsely confess? So within the personal risk factors, I further divided it into states and traits. The states include sleep deprivation, intoxication, drug withdrawal, and innocence itself. These are all mental states that can put people at risk for interrogation. With respect to sleep deprivation, and it's not, sleep deprivation, suggests that somebody has been deliberately deprived of sleep, but people sometimes deprive themselves of sleep, right? It's really about level of fatigue. What we find in psychological research is that fatigue impairs ability to sustain attention. It impairs our thinking. It impairs our cognition generally. It makes us more suggestible. It interferes with our ability to self-regulate. And in many, many ways, it impairs human functioning. And it's been demonstrated in a wide variety of occupations, including medical interns and surgeons. So pay attention on who's operating on you and what a good night sleep they had. And it is historically a method of softening people up before interrogation, particularly in times of war. Intoxication and withdrawal are also factors that can deplete people's ability to self-regulate, interfere with their cognition. We just don't think well. It impairs functioning in a wide variety of ways. Any state that impairs functioning tends to render people more susceptible to social influence and increases the risk of false confession under persuasive circumstances. Pain is another factor. I don't think I have a slide on it, but pain and discomfort is another factor that depletes self-regulation. So with traits, we mainly look at suggestibility itself as a trait. Individuals who might not otherwise be at risk differ with respect to suggestibility. You likely know people, some people who are just otherwise, well-functioning people, but they tend to be suggestible. So suggestibility itself is a trait. But usually when we're looking at what are the personal risk factors, we're looking specifically at youth, people with mental illnesses, and people with intellectual disabilities. So we define suggestibility as the extent to which within a closed social interaction, people come to accept messages communicated during formal questioning, as the result of which their subsequent behavioral response is affected. They're influenced by the investigators. Social psychology tells us that people are generally obedient to authority, which is a factor in an interrogation, that others' opinions and beliefs about us are important to us. We tend to conform to other people's expectations. And I'm talking about, not just talking about people with mental illnesses and developmental disabilities, but the human race in general has a high degree of suggestibility, and some have it higher than others. Oh, by the way, Good-Johnson has developed an instrument for measuring individual differences in susceptibility. So if you were to hire a clinical psychologist, a forensic clinical psychologist, to do an assessment in a contested confession case, you would want the psychologist to administer the Good-Johnson suggestibility scale.
Yeah, actually, Dr. Cutler, if I can jump in just for a
Please.
second, I just wanted to say that on the suggestibility issue, that is something that, I at least would recommend having an expert talk to the individual about, because we had a client that I worked with who had given a confession which he maintained was false. It never made sense to me why he would, because he's a big guy, he can kind of take care of himself, and had no difficulties in mental, cognition or any of the, wasn't young when it happened. But it turned out when we did a psychological evaluation of him, that he was kind of he was the younger brother that would always kind of go along with whatever the older brother said. So he just was very susceptible to authority. And so when he was kind of being led down that path by the detectives, it was in his nature to kind of just go along with it. I would imagine he would score extremely high on that, but it's not something that's obvious the way that youth is, or potential intoxication, or some of those other factors. So that's kind of one of more of the hidden issues to be able to look for, but it is something that you can get at even years after the confession that you're looking at. That, as I understand, Dr. Cutler, that stays the same, the level of suggestivity and susceptibility to authority. And it is something that you can still find out about years later without that. One question that has come up was, and I don't know if you can address this here or somewhere else, is there research on language barriers, particularly when you have untrained interpreters, as a personal trait that is that analyzed in any way as a risk factor, a potential language barrier?
It's a great question. I don't know of any research specifically on language barriers, but the topic of language barriers and immigration, I think, is a really important and timely one. But the lack of specific research on the topic is one thing. We know, generally in psychology that, from other contexts, that things like fear of reprisals renders people more obedient to authority. But no, I don't know of any specific research on in an interrogation and confession context. Anything else?
Nope, looks like we're good.
Okay. So let's move on to some of the other personal risk factors, starting with youth. A good deal of psychological attention focused on youth, adolescents, young adults, 18, 19, early 20s, and developmental psychology. Adolescence is thought to extend to early, and even the mid 20s before people take on really the characteristics of adults. If like me, you have children in their early 20s, you recognize this. But youth in general tend to be more susceptible to social influence. They're immature in their cognitive abilities, underdeveloped psychosocial skills. They tend to be impulsive, make decisions on the basis of short-term goals, which might include, getting out of the interrogation, rather than long-term consequences. They tend to be more volatile, and they tend to be deferential to authority. So, and maybe more likely to cooperate as they are taught to do, cooperate with police as they are taught to do by their parents. So youth in particular are overrepresented in cases of false confession and wrongful conviction. There is literature on safeguards for interrogating youth. There was a report produced by a national organization of police that I have access to. If anybody wants to get in touch, I can share. I think it's the International Association of Chiefs of Police, and even the training manuals on interrogation, such as the one produced by the Reed Institute, warns about the particular risk of false confession among youth. We also see risks of people with developmental disabilities, people with low IQ in the interrogation setting, including impaired communication and impaired social skills, which sometimes renders them looking more suspicious. They don't respond in the way that we might expect a more intelligent adult or even a more intelligent youth to respond. There are challenges in their abilities to understand and appreciate their rights. They can give the appearance of understanding without understanding it at a particularly deep level. They tend to conform. Again, they tend to be more socially influenceable with authority figures. They're more susceptible to leading questions, and they are challenged in their abilities to understand long-term consequences of their actions and tend to evaluate their courses with respect to short-term decisions. We see a lot of the same issues with, but some different ones with people with mental illnesses in interrogation. Disordered perceptions, impaired reality monitoring, impaired judgments, insufficient understanding of rights and impulsive behavior, inability to self-regulate or lacking self-control, susceptibility to influence, and they just tend not to be assertive. So you see a number of the same factors that come up with youth, people with developmental disabilities, and people with mental illnesses. And of course, these are not discrete categories. One could be interrogating a youth with both developmental disabilities and mental illnesses. So these risk factors can compound one another. There's been a fair amount of writing recently on this interesting topic of innocence, who are interrogated in how the state of being innocent can ironically serve as a risk factor for false confession. Well, how does that work? Innocent people actually behave differently in interrogation than guilty people. Innocent people tend to, they're more likely to waive their rights, to cooperate, and to speak freely with the police. They can come into the setting with the idea that I have nothing to hide. I didn't do anything. And when I explain it to the police, they'll understand. So they're just less likely to invoke their rights to silence and less likely to invoke their rights to lawyers. And the more they get tripped up, the more they participate, they end up getting tripped up. And even, the dynamic of the interrogation, they continue to profess their innocence. The investigators double down and put even more pressure on the innocent suspect until basically you wear down the individual's ability to self-regulate and defend themselves. So they're protesting, continuing to protest their innocence despite pressure, can make them appear even more suspicious. And even the decision to falsely confess is something that innocent people may think differently about, because an innocent person might say, look, I have no chance of convincing this interrogator that I'm innocent. So why bother? I'm frustrated, I'm exhausted, I'm wasting my time. Yeah, I did it. Falsely confess with the idea of surely I'll be able to explain to the prosecutor, and no judge is going to convict me of this crime because I didn't do it. My innocence will eventually become obvious and set me free. So innocent people behave in ways that that can trigger behaviors by interrogators, make them double down in interrogation, for example. They tend not to take actions to protect themselves, such as implementing their rights. They have naive beliefs that tend to get them into trouble. So being innocent can actually serve as a risk factor. Okay, let me pause for a second and before we get into the situational factors and see if we have any questions or comments.
Okay, so there's a question in the chat. Howard, I'm going to go ahead and read it unless you want to unmute yourself and go ahead and do that.
No, that's fine. You go
Okay.
ahead.
All right. So Professor Cutler, thanks very much for your presentation. In your view, is it coercive to offer to a subject of interrogation that a prompt confession / telling the truth may result in lesser punishment? Or, for example, of self-defense, even avoidance of prosecution? This type of offer is a standard feature of interrogation, but is it one that, as you would say, manipulates the perceived costs and benefits of various courses of action? Does it depend on whether the offer is honest or just a ploy, or depend on the subject of the interrogation, e.g. whether it's a youth, developmentally disabled, etc.?
So, the question pertains to, it sounds to me like we were talking about an explicit promise of leniency in exchange for a confession. Am I understanding it right?
Or at least,
Yes, here,
yes.
I'll supplement.
Thank you.
Sorry, but a lot to ask you to further
Sure.
clarify my long question. Yeah, I mean, this is as I understand it, a fairly typical feature of interrogation, at least that I've observed over the course of my career as a prosecutor, that if someone confesses promptly or cooperates with law enforcement, they are likely to receive some sort of benefit in the form of reduced punishment or lesser charges, or if they explain how their conduct was justified, maybe even avoidance of prosecution. And that may be a persuasive technique, but I'm wondering if you view it as a coercive technique. To me, I guess the bigger question is to what extent are persuasive techniques, coercive in their application?
Sure. One can talk about coerciveness of individual tactics. And that one, the tactic that, if I'm understanding right, is an incentive. You will receive more lenient treatment in exchange for confession than if you continue to maintain your innocence and are found guilty. Am I understanding it right?
Yes, and I guess that's, to some extent, that's a feature of our criminal justice system, or generally.
So one can weigh the coerciveness of individual tactics, or and also the experience of a combination of the interrogation as a whole. But explicit promises of leniency, my understanding is that even the courts consider that to be coercive. In the training literature, interrogators are trained that you can't offer explicit promises of leniency for a confession. That's a way to get your confession thrown out. Mm-hmm. Now, I'm not a legal scholar or even a lawyer, but that's what the training literature suggests. So what the trainers teach is that, so you can't explicitly promise leniency, but you can say things like, well, we'll talk to the prosecutor on your behalf. We can't promise anything, but we'll go to the prosecutor and say you were cooperative, you were a stand-up guy about it. And then they do other sorts of tactics, which we're going to get into when we get into what happens in interrogation, that are not explicit promises of leniency, but they amount to implicit promises of leniency. That happens through a process or tactics that we call minimization, or they call in the interrogation literature theme development. It involves suggesting things like, well, you wouldn't have done this intentionally. It had to be an accident. Or minimize the consequences of the crime. It's really not that big a deal. This guy had it coming to him, to begin with. And so those are clearly not explicit promises of leniency, but what they do is they lead the suspect to conclude on his or her own that he or she will be treated more leniently by confessing to this minimized version of the crime. And the interrogators actually teach that. They teach the investigators that that's what the effect of these sorts of minimization tactics have. They lead people to think they'll be treated more leniently for confessing. You can't tell them that, but you can make them think that on their own. So I guess I would come back to answer your question is, yes, I think explicit promises of leniency in exchange for a confession are coercive.
If you don't, sorry, if you don't mind if I just jump in there and add, yeah, I would agree that if you're holding out or trying to create the perception that there's some benefit for something that's clearly not in their benefit, then it's coercive. But I think it's also important to put it in context of how the interrogation works, whereas they've first been convinced that they're going to be charged and convicted pretty much no matter what they do, then the consequences they're facing are maximized or inflated. And then finally, this hope of leniency is held out to them. So it's made to seem really as their only viable option. And if you're backing someone into a corner, cutting off the options that they have until they really have just one that they perceive to be viable, and that's confessing, then yeah, I would definitely say that's coercive. That's really that's at the heart of our definition.
I'll just say from a legal perspective, most courts will find that if the court finds that there's been an explicit, if you talk to us then, discussion in the interrogation room, that will amount to an involuntary confession and will be likely suppressed under Miranda. But there's so much gray in that area in terms of, is that psychological coercion? That's a different issue that most courts don't find the psychological coercion in a lot of these factors to be enough to suppress a statement. But that one, it's some kind of threat of greater punishment, especially death penalty or life in prison versus a smaller charge or smaller imprisonment. That's a pretty clear line as far as the case law is concerned in terms of an involuntary statement and therefore violative of Miranda. So, but that's a whole different issue in terms of the psychological coercion factors that Dr. Cutler and Dr. Kaplan are talking about. I'm just going to note, Dr. Cutler, that we're at 3:11. And we promised folks to get out by 3:15. So I would suggest this is probably a good stopping point for us and to kind of hold the situational risk factors for June. But I absolutely want to see if folks have questions or things they want us to kind of think about for June, or questions or follow-ups from the discussion we've had so far. Feel free to unmute and ask, or raise your hand, or put it in the chat. Any of those will work.
I have a question. Earlier on, I think you said that you used university students for your experiments in interrogation. And I would assume that most university students are pretty well educated and don't have the kinds of issues that, for example, many of my clients would have had with regard to drug addiction, mental health, or mental retardation issues. So doesn't that skew your results when you don't use people who exhibit those kinds of characteristics?
Oh, it certainly does, but it's what's interesting about it is that in the laboratory research, we're able to get university students who are reasonably intelligent, mentally healthy, although we do have a fair amount of mental illness in our university population. But let's say, for the sake of argument, generally mentally healthy, intelligent, young adults, we're able to get fairly high rates of false confession from them. So I think if you add in personal risk factors, you would get even higher rates of false confession. Now that said, we would never say that the results of this experiment show that 30% or 60% of the people will falsely confess. We would never generalize the specific results from that experiment to what happens in your cases. But it does illustrate that those personal risk factors are not requirements for false confession, that even mentally healthy, intelligent adults are susceptible to these influences as well.
Well, and if you don't mind, I just add, most experiments are with university students, but not exclusively. There are some researchers who go out and recruit a sample of people with intellectual disabilities or people with mental illnesses. I think Gisli Good-Johnson, whose work was mentioned earlier, has done a lot of that work. Now, there are some ethical issues about subjecting them to a harsh interrogation like we might with university students, but there is some literature there you might want to look into.
Yeah, we don't rely solely on any one type of methodology, whether it's experiments or observational research. We try to be informed by the full range of scholarship that's available to us.
Anybody else with questions, raise hand, put in chat, or unmute? All those. Okay. Not seeing any more. It is 3:15, so we are at our normal stopping point. So Dr. Cutler and Dr. Kaplan, thank you so much for your time. And I, at least, and I think most everybody on this call, look forward to hearing more about this next month in the next part of the webinar. In the meantime, of course, as always, if there are questions or following up from this presentation, please let me know, and I'll be happy to connect you directly to Dr. Kaplan and Dr. Cutler so that they would be able to give you the information that you need, or if you need any of the resources that have been mentioned in the presentation so far, reach out and we can make those available to you as well. So thank you everybody very much. Dr. Cutler, Dr. Kaplan, thank you for your time, and we look forward to seeing you next month.
Thank you for having us.